Good morning. You're Richard Afongwaith, and Mr. Afongwaith's case is set for trial to begin with jury selection next Monday. Again, what is everyone's announcement?
Unfortunately, we had to file a motion for continuance. Mr. Floyd had to have a partial knee replacement last Wednesday. He's under doctor's orders not to sit or stand for prolonged periods of time, and so we had to file a motion for continuance. So I guess our announcement is not very much.
I got the message, Judge. I don't have an issue. I mean, I can't. He's got a medical condition.
Sure. Is there a timeline on that?
So in the next, I think he's got to follow up in 3 weeks, and then they'll reassess what he's allowed to do, right? Because like right now he's still like at home.
Sure.
So.
Okay, so I'm going to reset the case to the next trial docket to give them plenty of time. Obviously, you guys know this was going to be the number one probably. It's really going to be up there next time. So as far as age goes, I'm going to set it, and if I need to protect everybody, I can do protection orders from other courts if you need that as well.
Perfect.
Because it'll be time to get it way past time next time.
Yes, Judge.
Tell him I hope he gets better, and we'll see y'all the next trial docket.
Thank you, Judge.
You're free to go.
Thank you, Judge.
Mr. Franklin, you've got Ray No,
Yes, Your
2
Honor.
cases. Morning.
Good morning, Your Honor.
Good morning, sir. You're Ray No.
Yes, ma'am.
And in cause number 25 DCCR 0386 and 0387, Mr. No is charged with intoxication manslaughter and the other driving while intoxicated with a child under 15. And what is the announcement?
We are ready to proceed to trial by jury, Your Honor.
Okay, have y'all done a rejection? So what I'll hold it while y'all do. On the tablet, there's a plea bargain rejection.
Okay.
If y'all will get that signed with whatever has been offered that you're rejecting, and then I'll go over consequences, options, all of that, and then we'll get it on the trial docket.
Understood, Your Honor.
Okay.
Get that filed.
Yes, sir, thank you. I'll hold it while y'all get that taken care of. Is Dontrell Scott here? Mr. Scott, Mr. Johnson called earlier. He is not going to be able to be here. He's ill. I'm going to reset your case. You're free to go. Just stay in touch with Mr. Johnson in his office, and they'll let you know when you need to be back. Thank you, sir. Mr. Kelly?
Yes.
You've got Adam Moe.
He's present. Good morning.
Good morning. Good morning, you're Adam Moe? Okay, so we're here because Mr. Moe is on probation
Yes.
for I did a different type thing where Mr. Moe went and did some time on some of his cases
That's correct.
in prison, got out and is now on probation. Apparently, there are some potential issues with regard to where he's living that weren't issues with parole, but are issues with probation. Is that correct?
It sounds like they may be issues with probation.
Okay.
That's kind of why our original emergency motion had a strange title, because we didn't know what else to call this.
Sure.
Other than in an effort to make sure that he is doing everything correctly. I think our mission on that was, let's get in front of the court and make sure this is being done correctly.
So what's the issue, potentially?
Adam's parents, Jody and Chris Moe, who the court may remember, and they're present again today, while Adam was incarcerated, went to a number of lengths with the folks from parole to make sure that any home that Adam was going to live in upon his release and beginning the out of prison portion of probation and parole, because he's on parole too.
Correct.
That their home where he was going to live was in compliance.
Right. Parole's approved it.
Parole has approved it.
So where are we?
If the court doesn't mind, I'd rather not say the address.
No, I don't need that. I just need to know what the issue is with
The
probation.
issue is we are at 574 feet from a church that has a playground attached to it. And I don't want to speak for probation at all, but condition, I think it's 33, it isn't vague, but it's neither inclusive nor exhaustive. So I don't know exactly what the conversation was that probation had with Adam the day that he reported immediately upon his release from prison a couple weeks ago. And I don't believe that the conversation was, hey, you can't live there. It was, this is kind of an issue. So our position is a lot of effort was made.
So what's the issue?
Excuse me, so his condition number 33 says that he's not to be within 1,000 feet of places where children commonly gather. So
Right.
it's not limited to that list. And so I believe it's the 574 feet from the church with the playground attached is the issue.
Okay. I'm looking at the order now. Mr. Hoffpower, any strong feelings one way or the other?
Judge, we'll leave it to discretion of the court. I understand what probation is worried about.
Sure.
They wanna set them up to fail. I do understand that's unique with parole and probation, two different entities, but
Well, and
I
the
don't want him
offenses
violated.
were possession of child pornography.
correct.
There weren't any allegations of
There were 10,
assaults or anything like that.
Correct.
Okay.
just 10 charges of possession. And 5, we put 5, got penitentiary and 5 with probation.
Right. Is there a GPS at this point?
No,
He hasn't had his initial, actually, Ms. Simon is tomorrow. He just did intake and correct me if
Sure.
I'm wrong. He just did
No,
it.
and I appreciate being proactive, and that is good. We don't want to be in here the first month because there's a violation, which technically that would be a violation. There's no doubt that it's not vague. That would for sure be a
No,
violation.
in my reading too on the geography of this thing, Judge, is that if Adam were to make, I'm going to call it a left turn if I've got the map correct in my head. If he were even to turn incorrectly down the main street where this house is, that would be a parole violation. So our position is that parole's assessment here, and I know the numbers are what they are, but that it covers both issues. So it's not like there's some kind of leeway to go even closer to that facility. He isn't going that way. He cannot, or he's in violation of what's been set up forward.
Judge, Ms. Roach says if he lived there, he sentenced to his grandfather.
He's not, though. They specifically moved to
Okay,
thank you, though.
yes.
Miss Roach is watching to make sure, because if you were living somewhere already, there's kind of a grandfathered in, but they specifically moved to try to make it better, and,
Yes, ma'am.
okay. Well, here's what I'll do. I will allow a modification of number 33. But I want it to somehow, some type of addendum or attachment that's very specific, because this isn't going to be a exception for all, only for this specific. So I will need probably the address of that church, so that in the orders, it says that you can be within 574 feet of that specific place. 33 stays the same for everywhere else. So it can be 33 can read like it does, and then you can add with the exception of that one place. Also, at least for, I would say, 6 months or so, or depending on how probation feels once he gets going, and if he's following all the rules and treatment and things like that with the LSOTP and all of that stuff, then I want a GPS monitoring device on at least for a minimum of 6 months to make sure that the rules are being followed, that he's going the right way, and there's not any issues. And that way, once we're all more comfortable with how things are going now that he's out of prison, then I'm okay with getting rid of that once you're okay with that, if he's following through with treatment and everything like that. Make sense? Okay?
Just one question, I think it's not the school issue.
It's not the school issue, it's just the church.
The church. Yeah, the church with the, so I want that, that's the only exception, and the exception is the 574. So like you said, turn the other way, don't get any closer than what you're saying. That way there won't be an issue with it being any closer than what you're saying at any times that it would show up on that GPS. Make sense? Okay?
Yes.
All right, thanks. Y'all are free to go. No, ma'am. Mr. Burbank, Renisha Chason. Mr. Chason tested negative for everything, so that's good. Thank you. Yes, thank you. I need your signature, though. All right, ma'am, you're Renisha Chason. And will she waive the formal reading of the indictment?
She will, Your Honor.
And again, we're just gonna get a plea on the new indictment, reset the MTRP case, and come back and see where we are with the pre-sentence report. Is that correct?
That's correct.
Okay. That goes with that also.
Judge, just to refresh the court's recollection, the co-defendant in this case, who is the, in my opinion, much more culpable defendant, has already pled the TDC time.
Okay, thank you. Ms. Chason, in cause number 24, DCCR 2351, you're charged with the second-degree felony offense of injury to a child, and that's from July 19th of 2024. And how do you plead to that charge? I'm sorry? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand? And it looks like the agreement that you've made is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, states one.
It's admitted. Is there any evidence that Ms. Chason is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, but I'm going to reset your case so that the probation department can do a pre-sentence report. And if that can include an update also on the probation case where the motion's filed, so I can have all that information as well, and then we will come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing.
Would the court consider allowing her to remove the drug patch? It's costing some money that she doesn't have.
Not until sentencing. We're going to keep it on until sentencing. Make sure you keep it on and keep it updated, and then if everything goes well, it's about 5 or 6 weeks. Okay?
Maybe excuse me.
Yes, thank you. Mr. Franklin, on Mr. No?
Yes, Your Honor.
All right, again, sir, you are Ray No.
Yes, ma'am.
And Mr. No, in cause number, hold on, let me get it pulled up. Cause number 25, DCCR 0386, you're charged with a second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 0387, you're charged with the state jail felony offense of driving while intoxicated with a child under 15. In the same offense date of December 11th of 2024. And in that case, if you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
I have here on the tablet in each of your cases plea bargain rejections that you've signed with your attorney that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. In the intoxication manslaughter case, that offers for 18 years in prison. And then in the
I think I marked it wrong.
Should be 2
It should be.
2 years state jail?
Yeah.
No, okay,
Yeah.
all right. Okay, if I make that modification?
absolutely,
Thank you.
Judge.
So in the other, well,
And if you can't read my writing, I'm
nope,
happy
that's
to-
okay. I'm
redo it.
obviously don't know how to erase because now I'm just making marks all over this document. I feel like I know how to. Okay, so, good grief. It is a Monday. All right, so in that state jail felony case, the offer is for 2 years. In the state jail prison, it would run concurrently with the other case. You have every right to reject these offers and have both of your cases set for trial. I just want to understand, make sure you understand what the possible consequences are if you go to trial, what your options are, and do you understand all of that?
Yes, ma'am, I understand.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am, I do.
Okay, we'll get that done. And Mr. Coleman, is there any reason to believe that these offers would change? Is there any evidence that you're waiting on or anything like that?
No doubt.
So I do want to make sure you understand that after today, Mr. No, I won't accept this plea agreement. If you change your mind and want to enter a plea of guilty, that would be to something different or open to the court, unless there's new evidence that your attorney or the district attorney gets or finds out about between now and then. Make sense?
Yes, ma'am.
Okay, we'll see y'all at trial. We'll get it placed on the trial docket.
Thank you, Your Honor.
Thank you.
Your Honor, may I be excused?
Yes, sir, thank you. Yeah. See, Mr. Valles?
Yes, Your Honor.
Good morning, sir. On Crystal Calvillo,
Yes, Your Honor.
Calvillo, I'm sure I'm saying that wrong. Good morning, sir. Good morning, ma'am. You're Crystal Calvillo?
Yes, ma'am.
And Ms. Calvillo was previously in court and cause number 24, DCCR 2456, entered a plea of guilty to the state jail felony offense of theft of property. I've received that pre-sentence report. Any additions or corrections to that report?
No, Your Honor.
Up to the state.
All right, ma'am, I'm going to find that you entered your plea of guilty previously freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years.
Yes, ma'am.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And at the end of that probation period, if you successfully complete it, the case is actually dismissed and you will never have that felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and then you could be sentenced anywhere in the range of punishment, which is up to 2 years in a state jail prison. Do you understand? And there's no restitution, correct?
No.
Okay. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation, she's going to call you up to her desk when she's ready to go over all of your paperwork.
Thank you, ma'am.
Good luck to you, ma'am. Thank you, sir.
Thank you, Your Honor.
Ms. Holmes? You've got a sentencing on Cameron Gutierrez? Sentencing on Cameron Gutierrez. Good morning. Good morning. Are you Cameron Gutierrez?
Yes, ma'am.
And Mr. Gutierrez was previously in court and entered a plea of guilty to evading arrest or detention with the use of a vehicle in clause number 25 DCCR 0325. I've received that pre-sentence report. Have you both had an opportunity to review it?
Yes, Your Honor.
Yes, sir.
Any additions or
And
corrections?
from the defense.
Not for the state.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation.
Yes, ma'am.
If you do that, this is a great opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation at the end of the probation period, the case will be dismissed and you'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, which would make you a convicted felon, and sentenced to prison for anywhere in that punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation's gonna call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Thank you. Mr. Kelly. I lost Mr. Kelly. Mr. Mitchell, you've got John Van Wright, 2 cases. Good morning.
Good morning, how you doing?
Good, how are you?
Oh, I can't complain.
It's Monday. Nobody would listen if we complain anyway, right?
Drove in for Fort Worth to be here, though.
That's right. Good morning, sir. You are John Van Wright, and this is 24 DCCR 2485 and 15 23582. What is the announcement?
As far as the MTRP, it'd be not true, Judge.
Okay.
You know.
I think we'll just prove up the MTRP first, Judge.
Okay, so let's do this then. Let me get that pulled up. We'll go through that entire motion and then we'll get an updated report and set it for sentencing. Mr. Van Wright, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. And will he waive the formal reading of the motion?
Yes, Judge.
Mr. Van Wright, in clause number 15 23582, I have a motion to revoke your community supervision. Shows that you were placed on probation July 28th of 2020 for the 3rd-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 10-year term in prison, but it was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the offense of injury to a child, elderly, or disabled individual November 14th of 2024. And is that true or not true? All right, did you enter your plea of not true to count 1 freely and voluntarily? All right, then I'm going to enter that plea of not true on that count. I'm going to reset the case for sentencing hearing. About how long do you anticipate?
I want to know more than
About an hour or so, so we could do it maybe at the end of a docket? So we'll set it for 11, probably on a Monday, just at the end of one of these dockets, unless I can find a time when we're not in trial on another week.
Okay.
And that'll give y'all time for any evidence.
let me know or have Kelly or someone let me know so we can get witnesses here.
We'll do it. She'll be back tomorrow, and we'll get that set in the next couple of days. If I can get an updated pre-sentence report, that would be great as well. And then we'll see y'all back at sentencing. All
Sounds
right?
good, Judge.
Thank you. We need to get his print, please. Yeah, make a note for Kelly, though, that it needs a hearing about 1 hour. We probably can do it on a Monday unless we find another day.
Yeah, I think this was Judge.
Yes, thank you. Mr. Rennick, you have a sentencing on Alexandria Bledsoe.
Yes, Your Honor, she's correct.
Sentencing on Alexandria Bledsoe. Good, how are you doing? Thank you. Good morning, are you Alexandria Bledsoe? And this is 25 DCCR 0004. Ms. Bledsoe was previously in court and entered a plea of guilty to the state jail felony offense of abandoning or endangering a child with intent to return. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, sir.
Any additions or
Only
corrections?
one minor thing my client would bring up, the name of her employer was Cigna, correct, or Sigma? Sigma, it was listed as Sigma, and she was just worried that that might be an
Okay,
issue. I told her not to worry
Don't
about
worry
it,
about
but
that.
she wanted to bring it to the court's attention.
okay, thank you very much. Anything else?
So, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include completing an intensive parenting class. If you haven't already done that through CPS, there's going to be something through probation that you're going to need to do, obviously. If you do everything that you're supposed to on this probation and follow all of the rules and conditions, then this is an excellent opportunity because you do not have a felony conviction on your record. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? Okay, obviously, I would like to think that this was a huge wake-up call because this could have been very, very bad. And so take care of your child, take care of the classes, make sure you make all of the right decisions when it comes to that, and you shouldn't have any issue. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Thank you, Mr. Rennick. And Mr. Rennick, you also have Patrick Gallagher
Yes.
sentencing, 24 DCCR 2422
Yes, Your Honor.
sentencing. Patrick Gallagher.
He's also present. And I have one other after that.
Good morning, sir. You're Patrick Gallagher. And Mr. Gallagher was previously in court, entered a plea of guilty to driving while intoxicated, third or more. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, yeah.
Are there any additions or corrections?
Nothing was mentioned.
I didn't see any error.
So, Mr. Gallagher, you want to know what my big concern is? How long were you off probation for your DWI second when you got your DWI third?
I can't remember,
4 days.
4 days.
That's what it looks like to me. It expired, community supervision expired, looks like October 3rd of 2024 is the way this reads. New case, October 7th of 2024. What, if anything, have you done with regard to any kind of drug treatment? Anything on your own to stop using alcohol or drugs?
I quit drinking and I pray to the good Lord because I'm a single dad with grandkids, so that's over with.
Well, it should have been over with when you were on probation last time.
Yes, ma'am, I agree.
And I appreciate that you're praying, but sometimes that's not enough.
I agree with that too.
Are you still working
Yes, ma'am.
at Exxon?
Yes, ma'am.
Judge, there is one issue I need to bring up whenever you're done speaking.
Go ahead.
I'd spoken to the prosecutor about this. He is a full-time shift worker, and one of the issues was he had brought in his work schedule as he was, if the court was willing to, he had dates that he was not working to do the 10 days.
Okay.
And that is something I would bring it towards.
Oh. You weren't quick enough. You were quick, though. Okay.
It was the highlighted dates is when he is not working, that he was asking the court to. I know, he knows it's a big ask, but.
Well, I mean, I don't know, it kind of is, and typically I let people who are working do it on weekends. This is just how the weekends,
I have no
for his
issue with
weekends.
the erratic nature.
Here's the more, I guess, the part that's going to be potentially something that you're going to have to really figure out with your job schedule, and there's not going to be any excuses, is that you're going to have to enter and successfully complete the JCDI program. It is an intensive outpatient program. You're not the only patient that will have to do it on this type of schedule, but you're going to get started on that immediately without any mess ups, because if so, you're right back in here and you're going to be looking at going to prison. Do you understand? So what I'm going to do then, Mr. Gallagher, is find that you entered your plea of guilty freely and voluntarily. Have you been wearing a drug patch either, or no? Was that a condition of anything? I didn't,
No, Judge.
the bond, it wasn't a condition? Well, because there was, the blood came back with positive of Delta 8 THC. I'm sorry.
That's correct.
Yeah. Are you doing anything like that still?
No, ma'am, I work for ExxonMobil.
Well, I mean, did you work for them when you,
I did, but I had a vape that I didn't know was there, so that's history.
you're 52 years old and you're using a vape that you don't know what's in it? Do you want me to buy that?
You don't have to, don't matter.
I don't. Because if you don't know, then you should have known. So either way, it's ridiculous that, I mean, that's something that a teenager would come in and tell me, I got a vape and I don't know what's in it. All right, I'm going to do this. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow your agreement. Find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement. Well, actually, I'm not going to follow the agreement with regard to the length of time on probation. The fact that he was just off of probation, I think, warrants longer than a 5-year probation. The length of your probation period is ultimately up to me anyway, so it's not like I'm following the main part of the deal, but you still wouldn't have a right to appeal because that's up to me. So I'm going to find you guilty, sentence you to 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 7 years. You're ordered to follow all of the rules and conditions of probation. That's going to include entering and successfully completing the JCDI program and following, obviously, all of the rules and conditions. You'll have an auto ignition interlock device on your vehicle. Do you already have that? You're going to keep that at least for some amount of time. And if he has the interlock, you can make a notation. I don't need interlock and scram and portable, whatever they feel like is best through JCDI. Once that gets going, I'm fine with. I am going to order that you serve the 10 days upfront time. That is going to be on the date starting, I'm going to attach, I'll give you this copy as well, but so like where it says 9 nights, you work that night of the 9th. So you'll start on October 10th. I want you to turn yourself in October 10th at 6 p.m. and then you'll spend the 10th and the 11th, and they'll release you on the 12th. Okay? And then when you work days, what time do you get off?
4 o'clock.
4 o'clock p.m.?
Well, depends on when I leave, so it could be 4 to 4:30 to 5.
Okay, so the next time is going to be, since you're working days on the 16th, you're going to go at 6 p.m. on the 16th, and then you'll spend that night, the 17th, and get out on the 19th. If you don't have something written, days or nights, does that mean you're off?
We're so short-handed, it's a possibility, or I had to work overtime because I gave up 2 days overtime already for the 11th and 17th.
Okay. If it doesn't say days or nights on this calendar, does it mean you're off?
Yes, ma'am.
Okay. So that second one in October, you're gonna go, we're gonna get this done. Because that's your long days off. So we're gonna get that week done. So you're gonna go in on the 16th, and you're gonna get out on the 23rd. So that gives you one overnight, 16th, 17th, 18th. That gives you 7 days. And then that first one only gives you 2 days, so that's 9.
So you're saying go in on the 16th when I get off work that day?
Mm-hmm.
Okay.
And we're just missing 1 day.
There's 7 November on the back of it there.
No, we're getting this will be done in December, so you're gonna then go in on the 28th
Yes, ma'am.
at 6 p.m. and you'll get out the next day, and that'll take care of that last day. So, and then Anna will probably need that too. Make sure you get all of those done. Okay. All right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. You need to have a seat here in the courtroom and wait for probation to call you up. She'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Yeah.